Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to be talking about the ancient writ of Quo Warranto. Yeah, that probably sounds like something out of a 1930s movie with Errol Flynn, but it's not. So let's head on down to the beach and talk about that. So we start with a little bit of a history lesson. In ancient England, or early England, I guess the 15th, 16th, 17th century, there were all kinds of royal offices that someone could be appointed to. For example, the crown jeweler, right? Another office that you could be appointed to was the groom of the stool. Yeah, go look that one up on Google. Not a job I would ever fight anybody for. But the writ of Quo Warranto was designed to allow someone to question a person's entitlement to a royal office. In other words, if two people wanted to be the crown jeweler, or two people contended they were both appointed to be the groom of the stool, I love that name. Anyway, they could file, one or the other of them could file a writ of Quo Warranto to try and unseat the other person. And it became a very long and involved legal process in England and eventually more or less fell out of use. But being as how we incorporated all of the common law of England into our body of laws at the founding of the nation, the writ of Quo Warranto was one of the writs that was incorporated, and over time it has changed from what was truly a writ, a document sworn out in court, over to what is now called an information. So in order to bring an action in Quo Warranto, you do that by swearing out an information and filing it in the circuit court, at least in Missouri. You file it in the circuit court where the person supposedly usurping the office is located. And of course, the reason we're talking about a writ from the 1800s today is because the Attorney General of the state of Missouri has filed a writ of Quo Warranto against St. Louis City Prosecutor Kim Gardner. And getting the information in front of the court, this is what the Attorney General alleged. Janae Edmondson, a teenage athlete, was walking back to her hotel in downtown St. Louis. She was in town for a volleyball tournament, had just verbally committed to play sports for college in Tennessee, and Daniel Riley crashed into another car and struck Ms. Edmondson, severing one of her legs and maiming the other. She lost both legs, even though she survived. This is how the complaint against Ms. Gardner begins. We'll talk a little bit more about the allegations here in just a moment. Now, Gardner has not exactly enjoyed a storied history as the prosecutor in St. Louis. Shortly after she was elected to the office in 2016, she decided to take aim at the then sitting governor, Governor Greitens, by filing complaints against him for all number of things, including invasion of privacy and that sort of thing. It was sort of a sordid little tale. Governor Greitens had more or less committed the unpardonable sin of any governor of having an affair with someone and then trying to keep it quiet by threatening them. Not a good look, and he was eventually impeached and taken out of office by the legislature, which is kind of funny considering it was a Republican legislature that got rid of that Republican governor. But to make a long story short, during the prosecution phase of that in the city, there were a number of gross missteps by Ms. Gardner, and they resulted in, I believe it was either 83 or 87 page complaint filed by the Office of Chief Disciplinary Counsel. Issues that were raised in the disciplinary complaint. It says, Tisby made the following false statements under oath shown in bold, which respondent knew were false. Were you provided any information as regarding what KS told Ms. Gardner in her interview? Mr. Martin, no, sir, because I wanted to independently get my own take of the thing. I did not ask the circuit attorney what her take was. I did not ask for any notes or anything else. I just wanted to have an opportunity to talk to TS and just let her tell her side of the story. My question wasn't what you asked for. My question was, were you provided any information? No, sir, period. And did she, Gardner, tell you what KS said? No, sir. I specifically did not want to hear what she told the circuit attorney. I wanted to hear it for myself because I was conducting an independent review as requested by the circuit attorney. And that information turned out to be false because he knew they were false because he had received the notes. So those are some of the allegations. Now, when someone makes a statement like that and you're sitting next to them in a deposition and you're putting that witness forward, as a lawyer, you have an ethical duty to pull the witness out of the chair, take them inside and say, hey, look, you know that's not correct. You know that's not true. You need to fix that statement. It's a lie under oath, and you won't be charged with perjury, of course, if you go in there and say, hey, I misspoke. Here's what I meant to say. But you can't do that, and she didn't do that. She didn't make him do that. And as a result, the Office of Chief Disciplinary Counsel went after her for essentially knowingly suborning perjury. Now, the Office of Chief Disciplinary Counsel in Missouri is designed to prosecute ethics complaints. So if a lawyer goofs up, if a lawyer pulls, for example, an Alex Murdaugh and steals from clients, well, that's the group that gets involved and works to get him removed from the office of attorney, which they do through prosecuting that up through the Supreme Court. And in that case, although the complaint was very long, it wound up being negotiated down to a reprimand. Even though some of the allegations in it, including possibly perjury, were pretty significant and pretty shocking in the short run. It very quickly left the attention of the news media, and it wound up being settled several months later with this kind of a quiet agreement that the prosecutor, the Office of Chief Disciplinary Counsel, would recommend a reprimand to the Missouri Supreme Court. The prosecution that she engaged in with regard to Governor Greitens was also notable for a prosecution that arose out of it by special prosecutor, because Kim Gardner could not bring this action against one of the investigative agents that she hired to go after the governor, a guy by the name of Tissaby, who was prosecuted for perjury during that investigation, or during certain testimony that he had given in concert with that investigation.
And I guess my concern is, I mean, you have lied under oath before, right?
I'm not answering that.
Well, you testified earlier that's what the FBI concluded,
That's
right?
what the FBI concluded, not me.
And so it was a very interesting and troubling time for Ms. Gardner, I'm sure, and also for the citizens of St. Louis, who probably really didn't care that much who the governor was, probably really didn't care that much who the prosecutor was, would really just like to live in peace and harmony with their neighbors, except for the fact that the neighbors seemed to be engaged in all measure of drug running and shooting the place up. So flash forward to 2023, and the Office of Attorney General files a petition in Quo Warranto against Ms. Gardner. In the months after Governor Greitens' case was sort of put to bed, there began a stream of departures from the City Prosecutor's office. Now, this is an office that handles a lot of criminal cases, and I think the general tenor was that the prosecutor had simply decided not to prosecute, for the most part, anything except very serious misdemeanors and felonies. So things like shoplifting and that sort of thing often went unpunished, unprosecuted, and I think that made some of the businesses in St. Louis rather angry. But the main problem was that as things went on and more prosecutors left, well, there were only 5 prosecutors to handle 200 murder prosecutions and 200 other serious felonies. So you have 5 attorneys handling 400 cases. You don't have to be a math whiz to realize that that is simply an untenable number. It means that if every one of those defendants invoked their right to a speedy trial, there would likely be no speedy trials, and many of those people, particularly the murder defendants, would go free, which means that the murder cases tend to be accelerated and prosecuted more quickly than some of the less serious felonies, which are still serious, of course, including drug trafficking and assault with a deadly weapon, all of these sorts of things, possession of a firearm by a felon, all of these things are not being prosecuted because the murder prosecutions take precedence and there are only 5 attorneys to do that. So Attorney General Bailey brings this petition in Quo Warranto, and he makes 3 specific allegations for why she is failing to execute the office. And those are, she has failed to manage and prosecute criminal cases. So 5 attorneys for 400 cases, that is an abject failure of leadership. It's an abject failure of doing your job. She's also failed to inform and confer with the victims in some of these felony matters, which have been pending for months and months and months. And of course, most of these people are out on bond, refuse to exercise her judgment in deciding which cases to prosecute and which cases not to prosecute, which is a little bit of a stretch as far as a petition in Quo Warranto goes. But the bottom line is that he's brought this action and he's made those specific charges. And I doubt very seriously if this would have come up but for a tragedy that recently occurred there. There was a volleyball player who was in from Tennessee at a volleyball tournament who was hit by a driver who was, I believe, fleeing the police. He had been out on bond. He had numerous interactions with the police that would have justified revoking his bond, and the prosecutor's office never attempted to revoke his bond. Now, in fairness to the prosecutor's office says they made 2 verbal attempts at motion hearings to revoke the bond, but those attempts are not reflected in the transcripts of those proceedings. So either someone is not being candid with the media, or the fact is nobody ever attempted to revoke this person's bond. The failure to revoke that miscreant's bond, I think, is the main reason why the petition was brought at this point. But there is ample evidence, I think, of misconduct in office, including the misconduct that resulted in her getting a reprimand, that would justify having her removed. Now, she's filed a response. This is Ms. Gardner's response, and as you can see, it starts off with a bit of sanctimony. It says, unlike the petitioner, Ms. Gardner desires to comply with the Missouri Rules of Civil Procedure, which require that averments be made in numbered paragraphs. Okay, when you start attacking the complaint on the basis of whether they numbered their paragraphs or not, it may indicate you are not paying particularly close attention to what's being alleged, and that seems to be the case here. And in the response, she generally denies everything, and then she filed what's called a motion to dismiss, saying that it should be dismissed because none of the things that are alleged, even if they were true, would be grounds for removing her from office. There's only one problem with that, and let me show you what that is in the statute. This is the statute that governs Quo Warranto and the information, and it talks about usurping, intruding into, or unlawfully holding or executing any office or franchise. And of course, this is about unlawfully executing it. It says the same shall not be dismissed or discontinued without the consent of the person named therein as the relator. And of course, the person named therein as the relator is Mr. Bailey. So it's doubtful that the dismissal will happen. So essentially, applying the statute, that means that even if you claim that there is nothing there, that there's no there, the case still has to be tried to the judge. And of course, this is one of those things that is tried to a judge. Presents an interesting question on civil procedure. We'll have to see how the courts resolve it. So as you can see, the case can only be dismissed if the relator, in this case the Attorney General, agrees to dismiss it. And I doubt very seriously if the AG, having brought this action, is going to back down and agree to have it dismissed. So the judge that's been appointed is Judge John Torbitsky, who is on the Eastern District Court of Appeals in Missouri. He was a former law clerk to Judge Zell Fisher, who is a judge on the current Missouri Supreme Court. And Judge Fisher is pretty much a law and order guy. I think Judge Torbitsky is pretty much a law and order guy. And we'll just have to see where he comes down on this. He gave Ms. Gardner 14 days to file an answer, and he allowed her to have an out-of-state lawyer from Harvard to defend her. And of course, this is going to be one of those cases where the law is probably more important than the facts, because the facts are baked into the record at this point. There are numerous cases that she refused to prosecute, not because crimes didn't occur, but because the arresting officers were officers that she didn't like and that she didn't trust and that she believed were abusing their authority. And I understand that, you know, there can be police officers that you think might be stepping over the line, but there's a remedy for that. There is a disciplinary process within the police department and within the state. There is something called POST, Police Officer Standards and Training. You can go to POST and you can get a police officer's license revoked if you believe that he is stepping over that line. She didn't do that. She just refused to prosecute these cases. And then, worst of all for her, a gentleman by the name of Marvin Tier, who has been a lead prosecutor in some of the more notorious of the cases that her office has prosecuted, has determined that he will resign. Now, I don't know if that means there are now only 4, or whether it means that the 5 who are left to prosecute felony cases are tremendously overworked. But I can tell you this. The prosecution of a felony matter involves a lot of documents. It involves talking to a lot of witnesses. It involves talking to a lot of police officers. It involves preparing people to testify at trial. And it involves more or less mortal combat in court. It isn't something that you can handle 500 or 400 cases with 5 lawyers. It just can't happen. And that, I think, is at the heart of it. Now, her answer to that in the motion to dismiss is, well, that's not misconduct by me. That's just the failure. I can't get people to fill these roles. And that's not misconduct. That's just failure to staff the office. And that's not something that, is subject to removal from office. I don't think that motion to dismiss will go very far. And I do think that the action will be tried to the judge. It's not a case where you can get a jury to decide these issues. It will be tried to the judge, and it will be up to him to determine whether, in fact, Ms. Gardner should lose her office or not. This will be a very interesting case. I will try and follow it. There are a number of undertones in this case, and a lot of them are political. A lot of them are other kinds of undertones that I don't believe should have any bearing on the outcome in this case. Either someone is not fulfilling the duties of their office, or they are fulfilling them, and that seems to me to be a fairly binary issue. The political affiliation of that individual should not be an issue that comes up, nor should anything else. It should be the facts of the case that decide that matter. So that's what I have for you today. You can find a lot of information about this if you simply Google Kim Gardner, St. Louis Circuit Attorney, and look at the news media from various sources. You can find a little bit more information about some of the historical issues that I've raised. Also, back in May of 2021, when the initial ethics complaint came out, I did a video on it. I will try to remember to link it here in the video, but if for some reason I don't, you can find that on my channel. So your mission today, hopefully, is to go out and find somebody that you can help. in some way, in some small way, do something nice for someone. And I hope that you will have an opportunity to do that. Thank you very much for watching. If you have any questions, leave them in the comments down below. Like, share, subscribe, you know, all the stuff everybody asks you to do. It does help us with the YouTube algorithm when you do that, and I greatly appreciate it. Again, thanks for watching. Have a terrific day, and I'll catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.